Hello and welcome to Bangalore International Centre's very own podcast, BIC Talks. Bangalore International Centre is a platform for informed conversations, exchange of ideas, and a space for arts and culture. BIC Talks brings the essence of all that the physical space stands for and more to your doorstep.
How are people often unlawfully detained in India? What laws and judicial challenges make this possible? What is the UAPA, the Unlawful Activities Prevention Act, and how do such acts give the police sweeping powers in the country? Hi, I'm Pavan Srinath and welcome to BIC Talks. To help us understand all this and more, I'm joined today by Mayur Suresh from London. Mayur is a faculty at the School of Law at SOAS, the School of Oriental and African Studies. He was previously a practicing lawyer in Delhi, and he works extensively on anti-terror laws, legal theory, sexuality, and gender identity. Mayur, thank you so much for joining me.
Thank you for having me.
So Mayur, core to our fundamental rights and freedoms is this idea of habeas corpus, right? It's old but relevant to this day. And it's about how none of us can be unlawfully detained or imprisoned. And I'm seeing that, as we're recording this, even this week, we see a journalist of the likes of Arnab Goswami getting bail from the Supreme Court. While simultaneously, we have seen several people, including journalists and activists, who've been detained by the police for various reasons for months on end. Right? So what fundamentally makes this possible in the Indian criminal justice system?
More broadly in the Indian criminal justice system is just the fact of endemic delays, the fact that you have many people who are just arrested, put into jail, waiting for their trials to start or to complete. And so that's generally what the problem is. Many people have said different things. There was a report probably a decade ago now about cases in Delhi where most magistrates' courts were choked up with just frivolous cases. Frivolous, like, for example, check bouncing cases, which shouldn't be a criminal offense, but is. And these are choking up the magistrates' courts, which means that magistrates have less time to deal with ordinary applications of bail and other hearings, which will kind of put some checks and balances on the police forces. So that's, one explanation for it. But I think endemically, there's an issue of just not enough judges to do the work of letting people out on bail. There's also, kind of coming to the topic at hand, there's also questions of the use of extraordinary legislations, which basically deny people the ability to get bail. The assumption is that you are so dangerous or need to be in custody pending your trial. Obviously, the UAPA, the Unlawful Activities Prevention Act, is one of these laws that effectively incarcerates people for not just months, but years and decades on end without a conviction. There are other laws at the state level. The Maharashtra Control of Organized Crime Act is one example of that that's applicable in places like Delhi as well, which effectively deny bail to people. So the presumption is, even though it's unstated, the presumption is that you have committed the crime and therefore you need to be kept in jail until your trial comes to an end. And
is this lack of judicial capacity also perhaps a reason why, if you have 100 such cases and you have the capacity to hear 2 or 5, there is also a case for selectiveness, and where you can be biased in choosing which 5 of those cases that you might want to hear speedily? Does it also come from the same idea that, there's just too much backlog and too much load on the judicial system?
I think the question of the selectiveness is more of a question of the higher judiciary than it is the lower judiciary. The lower judiciary has a roster kind of set. So every judge will have these cases. The judge can set his own roster, but every case has to be heard, let's say, within every 2 weeks or every week. And therefore, there's kind of a regularity to it. The issue with the higher judiciary is the question of the roster, right? So the judges have much more discretion on which cases to take up, which cases to put into cold storage, which cases deserve an urgent hearing and which cases don't. So, the case of Arnab Goswami that you mentioned is kind of the case in point. He has the lawyers, the wherewithal, and the kind of public persona. I was going to say notoriety, but perhaps that's not the right word for him. But he has the public persona in order to to have the court's attention. Whereas, other people, Sudha Bharadwaj, kind of the lawyer who was picked up on terrorism charges, Varvar Rao, while they're known amongst, civil society circles, they don't have that thing, don't have the public persona. And frankly, sometimes there may be just this aversion to deal with anti-terror cases on the part of the higher judiciary. So, it's difficult to discern what the reason is, why certain cases get preference and why certain cases don't. So lots of speculation on my part, but what is at fundamental at the idea of selectivity is the ability to choose your cases, that the case that you want to hear and the case that you don't want to hear, and the cases that you choose to delay. So there's a lot of ability to be very selective, as you put it, in the higher judiciary more than it is at the lower levels.
Okay. And Mayur, you mentioned a little about the UAPA and other such laws. So can you tell us about how these laws even came into being, and what are the provisions in them that allow for such sweeping powers to be given to the police in terms of arrest and detention and denial of bail?
So obviously all of these laws come from colonial times, right? So the colonial state early on basically figured, even though it was kind of quote unquote came in to do the civilizational work of the rule of law, to say that, natives didn't have any conception of the rule of law, and therefore we must bring the rule of law. Rule of law means that you must know the procedures in advance, that there must be fairness, that all these procedures must be applied consistently. Despite all of that, and lo and behold, this colonial state didn't live up to that, which is why you have laws like the Indian Penal Code, the Code of Criminal Procedure, the Indian Evidence Act, the Code of Civil Procedure. These are all they come from the impulses of codification and this idea of the rule of law, that everyone should know what the procedure is, what the law is, and it should be applied uniformly. But as historians have told us, that obviously this is not the case. And what they effectively did was to use different procedures for different types of crimes. So, for example, acts of extreme violence were dealt with a different procedure. So one of the laws that we now know as the Rowlatt Act was preceded and was followed by several laws in which there was separate procedure involved. So, for example, bail would be much more difficult. You would go to different tribunals. You wouldn't be heard by the regular sessions court judge or the magistrate that ordinarily deal with your case. So there were kind of these number of procedural innovations or differences or special ways of dealing with certain types of cases that were endemic in these laws. And it wasn't just the Rowlatt Act. For example, there were laws going back as far as 1818, which talk about different procedures for a specific set of crimes. In the 1930s, the government of India at that time passed this thing called the Criminal Law Amendment Act. And the Criminal Law Amendment Act is kind of the progenitor of many of the anti-terror laws that we see today. So the Criminal Law Amendment Act, what it did was it allowed the local district governments to ban organizations. And what the consequence of that banning, was that the organization would lose its funding, would lose its bank accounts, its property could be sealed, but also being a member of that organization was also a criminal offense, right? So this kind of idea of membership of an organization that has, I forget the exact terminology, but an organization that is a threat to public peace and security is probably what kind of the gist of what the section said, could be banned. And then if you're a member of the organization, you could be punished for being a member of the organization. So a number of organizations were banned under the Criminal Law Amendment Act. And this is not only the Congress Party, but, trade unions, right-wing organizations, left-wing organizations. So, a whole gamut of basically anti-colonial organizations. In the early 90s, soon after the Constitution was promulgated, there was kind of one of the most famous initial cases of the early constitutional period, the case of V.G. Rao. So the government of Madras, just after independence, figured that the People's Education Society, which was they claimed was a front for kind of the left-wing parties, was banned by the government of Madras. And the ban, again, was an executive fiat, right? It was done by government order with no judicial oversight. And interestingly enough, in the colonial period, Jinnah, who was a member of the central legislature, argued against this law. He talked about how the law was unfair. It did not conform with the rule of law, simply because organizations could be banned without any judicial oversight. And what flowed as a result of that is people could be just called as members of the organization and then prosecuted. Right, so the initial banning of the organization without judicial oversight had repercussions to people who were purportedly members of the organization. Anyway, coming back to 1950, what happened is that V.G. Rao basically said that under the new constitution, you need to have judicial oversight. You can't just have banning by executive fiat. To cut a long story short, the Supreme Court agreed with him and struck down the law and said that you can't ban an organization and the consequence being that people are put in jail as members of the organization just by an executive order. Fast forward a couple of years later, in the 1960s, this is just after the Indochina War, the Congress government at the time was facing numerous difficulties around the country, separatist movements around the country, and they passed the 16th Amendment, which talked about the duty to promote national integration. And following that, they enacted the Unlawful Activities Prevention Act. Again, this allowed for the banning of organizations, but this was done so the government could ban an organization, and then the ban had to go before an independent tribunal, and then the ban was either upheld or rejected. But it included crimes of membership. So to be a member of a banned organization was itself a crime. Again, to move forward a bit, the idea of banning an organization by executive fiat comes back in POTA, the Prevention of Terrorism Act, which was enacted after 9/11 in the US in 2002. Over here, it was finally enacted. So POTA basically allowed the government to ban an organization by executive fiat. We already know because of V.G. Rao's case that was unconstitutional. However, the government all it had to do was list an organization and ban it. And then flowing from that, people who could be alleged to be members of the organization were accused of terrorist offenses. And separately, of course, there was a separate chapter on separate definition of terrorist offenses, which we can come to in a bit. But when POTA was repealed in 2004, the Congress government basically said, we know that POTA has been used to persecute minorities. We know that, therefore we're repealing it. But they kind of did a sleight of hand. They said, we're going to repeal the most egregious, we're going to repeal all of it and put most of it into the UAPA. What they left out were some of the procedural horrors. One of the procedural horrors that was from POTA and TADA that preceded it was the idea of confession to a police officer. So that wasn't included in the UAPA. But all of POTA, minus certain procedural and evidentiary innovations, were put into the UAPA. And we're kind of left with the UAPA today as an act that allows for banning of organizations by executive fiat. And flowing from that, people are accused of being terrorists just by... There's a recent amendment made more recently about how people can be listed as terrorists. So the government, all it has to do is name them and they can be listed as terrorists.
So you're a member of that organization because the government says that you are. That's it.
Basically what it is. But even independent of that, they can name a person A as being a terrorist without going through due process, without going through any judicial fora.
And once they do so, is there a judicial check that happens, or is that only after a case goes to trial and is heard in its entirety in court?
So there are two separate processes. One is, for example, the government accuses person A of being a terrorist in a trial court, right? So they'll have to go through the ordinary judicial procedure. But there's another provision which allows the government to list person A as a terrorist, which is more egregious because, you're not going through any judicial forum. There is some review process of that. But for example, under POTA, there was a review process in place to review the executive banning of organizations. But there was a RTI filed sometime after that where basically the government hadn't even set up a review committee, hadn't even put in the processes by which to review the designation of a terrorist organization. So I'm not sure under the new provisions whether a person who has been listed as a terrorist can review them. Technically, that person could be able to review, but I'm not sure if the mechanism has actually been put into place.
And here, Mayur, when you say government, can state police forces as well as the government of India and the Home Ministry both take action on this, or is this sort of exclusively in the domain of the union government? So
the union government has a power to list a person as a terrorist, right? But in terms of who is prosecuting people for being terrorists, through the trial court process, it's the state government usually. However, in Delhi, of course, it's effectively the special cell, which is, under the central government. But there is another enactment called the National Investigation Act, which is a central police force, which allows them to investigate and prosecute acts of terror as well.
So when we are seeing journalists and activists who are being arrested in the last couple of years, around the anti-CAA protests and even since then. So is this the act of individual state police forces, sometimes the Delhi police, which is directly under the ministry? How should we be looking at this?
Yeah, so it's part of the difficulty of arguing for a big concerted conspiracy, as you point out, the disparate nature of it, right? So, for example, state governments around the country will be prosecuting people for example, the Bhima Koregaon was prosecuted by the Maharashtra police, right? And I'm sure the special cell will technically under the Home Ministry, I'm sure they would deny any direction from the Home Ministry. But what the story they would tell, or any police station they tell, that we received information about a criminal offense and we decided to investigate, and we found that there was credible evidence that these people had committed terrorist offenses. That's why we're prosecuting it. Even though I think there's great amount of evidence, so to speak, that there is a kind of concerted campaign against anti-democracy activists, I think it's difficult to prove that point.
And Mayur, you've also written and sort of tracked extensively some of these terror cases, even when they make it to court. So now, whether a case makes it to court or not, essentially under these laws, so people are pretty much guilty until proven innocent, which is supposed to be the opposite of how law is supposed to treat individuals, right? That you're innocent until you're proven guilty.
Yeah. So when you're accused of being a terrorist by the police, what happens is slightly different from what happened under an ordinary law, right? So, for example, under an ordinary law, you'd be taken into custody perhaps for 2 weeks at a maximum. Under the UAPA, you can be taken into police custody. That is, you're kept in the police station for at least for 30 days and perhaps even more.
Okay, so you're not in judicial custody. You're not in jail.
No, you're not in jail. You're with the police, right? And what often happens is there'll be multiple FIRs relating to the same person. Right. So let's say there is a conspiracy that there is an allegation that person X is a Maoist. Right. Person X has cases against him in Maharashtra. Let's say, just for example, Maharashtra, Delhi, Andhra Pradesh, Telangana. Right. So there are separate FIRs. So basically, in each of those cases, person X can be held for up to 30 days in police custody. But what often happens is this passing the parcel type thing, where person X goes to 30 days in custody in Delhi, let's say, and then 30 days after that, a person X the Maharashtra government police will come and say, we need custody to investigate our offenses, and then the person X will go to Maharashtra for 30 days, and so on and so forth. So this person can be in police custody for a very long time before they even actually make it to the next process, which is effectively the charge sheet. And even then, so the charge sheet can be filed up to 6 months after the initial arrest is made. So under ordinary law, it has to be within 90 days the charge sheet has to be filed, but on the UAPA, it's extendable past 180 days. So again, the same round robin thing will happen. For example, you 180 days here, 180 there, 180 days there. So people can, 180 days is half a year. So people can easily, just in the whole pre-trial process, can be in that process for years and years. And then finally, when you get to trial, you have the kind of, obviously you have the regular delays, but in some of these cases, there are tons and tons of witnesses. So it's like hundreds and hundreds of witnesses, often which people are proving, no one's contesting it. For example, let's say there is a bomb blast, the prosecution will bring many, many witnesses to prove that there was a bomb blast. However, everyone knows there's a bomb blast. The defense isn't denying that there's been a bomb blast. So in effect, the prosecution is proving a non-contested point, which it doesn't need to prove. So there are all these ways, kind of these minute technical ways in which these cases can go on for years and years. So some of the people I met during my fieldwork, one is the person called Mohammad Amir Khan, who's written this wonderful book called Framed as a Terrorist, who was in jail for 14 years. And finally acquitted of all the charges. And very similarly, he was accused in Delhi, accused in Rohtak, accused in different places. And just kind of the process that I outlined earlier was he was kind of bounced around from case to case to case to case. And every case would delay the other one, which meant that he was in jail, like effectively waiting for his case to happen for 14 years. Another equally heartbreaking case is a case of a person who I met called Syed Mcbulsha, who was arrested and again kept in jail for 14 years. The only evidence against him was that evidence, quote unquote, was that he had the stepney, the spare tire of a car that was allegedly used by people who are accused of doing terrorist crimes. And he was arrested at the age of 18 and, released 14 years later. And so it's devastating. And it's the ways in which these laws are used.
So while you're in police custody and being bounced around, does that process itself make something like bail harder, or is just the charge of a terrorist activity make bail almost impossible?
No. So bail is almost impossible, primarily because of the way the statute is worded, right? So bail, you can't have it unless you can't have it unless the prosecutor agrees to give you bail, which is different from not any other law, but most standard under the CRPC, on the Code of Criminal Procedure, where you ought to be given bail. The presumption is you should be given bail unless there are reasons why you should be kept in custody. So, bail is virtually impossible. And under the UAPA, a similar bail provision under the Prevention of Money Laundering Act was struck down some years ago, virtually identical to the UAPA. If the courts are saying under the Prevention of Money Laundering Act that the bail provision is unconstitutional, clearly they're unconstitutional for the UAPA as well.
And yeah, one of the things actually that I only learned properly in our discussion today, that I thought we had repealed the worst of the acts like POTA and TADA, but clearly they have just been absorbed into this catch-all UAPA right now. So Mayur, in this process, right? So do you see any arms of the judiciary that have done perhaps a little better than others at upholding civil liberty at the end of the day? I know that some of the laws, especially like UAPA, make that harder by design. But do you see any particular institutions who do a better job?
It's difficult to make a India-wide thing because my experience has only been in Delhi, and my research has only been in Delhi courts. But what I think people who are doing the most work are probably the trial courts, right? And the trial courts are trying basically because there's a certain commitment to ideas of evidence and due process and procedural justice that you see in trial courts, which you probably see less in the higher judiciary. So the trial courts are very, very, and it might seem a bit pedantic and might seem a bit like, niggling that people are so concerned about whether documents are signed properly or whether the police have filed the paperwork properly or what they've said in court. But these are important things. These minute procedures are what provides a check on police misconduct or police false prosecutions. And so the trial courts are kind of, as far as I've seen, have been doing their best. In fact, there was a trial court judgment some years ago about this fake encounter case called the Kapashera encounter case. So basically the special cell in Delhi fabricated an entire encounter. They said that the litany of misconduct is difficult to encapsulate in one podcast. But basically they fabricated paperwork. They said, for example, they arrested the accused from one place, actually they arrested from somewhere else. They said they fired certain shots. However, in the ammunition logs, it was found that no cartridges were discharged. They said they went to a certain place to arrest this person. However, in the vehicle logs, that was never mentioned. So there's kind of a litany of like procedural malfeasance. But in that trial court, basically, the trial court basically said this case is obviously fabricated. The police have made a false prosecution against these people and actually directed a complaint be registered against them, against the police officers for fabricating the cases. What then happened was that the police went and appealed to the High Court, and the High Court acquitted the individuals, but basically didn't allow the prosecution of the police to go forward. So the trial courts are doing their best, I guess, as much as they can. But I think from what I've seen, I'm sure the story is different in different places, and I'm sure people could give me instances where trial courts have been as prejudiced or haven't lived up to the duties. But as far as I've seen, I think the trial courts in Delhi they're trying their best.
You mentioned the VR Rao case soon after Indian independence, right? So have there been other such cases or judgments which are trying to set a new positive precedent in some of this executive overreach that is happening by design under the law? Or is that the pending challenge for civil society and for the rest of us?
So there are challenges very similar to VJ Rao, but as far as I know, they haven't been adjudicated on yet. So there have been constitutional challenges to the UAPA. Well, some of them have been dismissed. And the UAPA has been upheld. But there is one that I know that's presently in the Supreme Court, which has been pending for a while. I think basically what you need is a movement like you had the anti-CAA movement. I think we need is an anti-UAPA movement, because obviously it's affecting so many people. It's across the country. It's something that civil society really needs to take up. And the UAPA definitely needs to go. It's just a question of how and when.
That was sort of my parting question as well, which is about how do we change this, right? Because clearly governments, and this is not about any particular party in power, I think, laws like the UAPA serve those in power extremely well. I mean, no matter what leaning they might have. So there will be a natural tendency for any incumbent to not want to change, quote unquote, dilute the provisions of UAPA that are problematic to civil rights. So how do you see this changing? It has to be like an outside movement? Can it be changed in the courts? Or do we finally have to apply enough pressure that, Parliament takes action in some way or the other?
You're right to say that it's been used by all parties. I mean, just thinking back to like the debates in 1967 when the UAPA was passed. So then there's debates about how it's going to be misused. This is from the left and the right. Misused by the Congress Party to cement its own rule. It's an extension of emergency government. And the Congress Party knew this, right? So in the 80s when TADA was enacted, the Terrorist and Disruptive Activities Prevention Act, the statistics were staggering. So something like 70,000 people were arrested under TADA. Of that, something like only 400 were ever convicted, right?
Wow.
And even similarly, even now, under the UAPA, you have the latest NCRB, the National Crime Recourse Bureau. I think something like, they don't tell us full number, and it's difficult to track this over time or collate acquittals to actual cases because of the way statistics are presented. But basically, of all the UAP arrests, I think the statistic was something like 9% lead in a charge sheet. So you have all these people in jail. Of every 100 people in jail for UAP offenses, that means they could be in jail, in police custody for how many ever days, and then judicial custody after that for months and years on time. Only 9% of them are ever charged with terrorist offenses. Of that 9%, only 1/3 are ever convicted. So it's just staggering the way in which the UAP is being used. Everyone knows. So Gautam Navlakha is currently in jail for UAP offenses. Wrote a long time ago that the UAP is not meant to achieve a conviction. No one believes. The police, in my conversations with them, the lawyers in my conversations with them, believes that most people will be convicted in the UAPA. The aim of the UAPA is to keep people in jail as long as possible, right? And you have this whole population in jails around the country who are under trials for ordinary offenses but particularly for UAP offenses, who are just sitting there waiting as life goes by for the trials to come to an end. I think once you look to the human stories of what's happening, Mohammed Amir Khan's book and Vernon Gonzalez's book about their time in UAP trials are deeply moving because they talk about how they put in jail for no reason. And so I think those human stories need to come out. And I don't know what the big organizing principle or big organizing emotion is, but it's very difficult to look at these cases, when you look at these human cases, and not to be moved by them. I mean, I don't see the present parliament doing anything about it. I just hope organizations are documenting stuff for a future time when this is possible. For example, the Jamia Teachers Solidarity Association in 2012-2014 had released a report called Framed, Damned and Acquitted about fabricated cases in Delhi. They kind of listed the number of cases that the special cell had brought against people under the UAPA, and listed the ways in which they were damned by the media and framed by the police and finally only to be acquitted. So there are ways. I think a lot more documentation needs to happen around the country. We don't have enough. I think we need to have more of the kind of the stories of people who are going through these trials. I mean, this is not to deny that people are committing terrorist offenses. We know that people have committed acts of violence, but the vast majority of people are accused of minor things, putting up a poster. For example, Siddiq Kappan, the journalist who was arrested on his way to Hathras for reporting on the rape over there, was put under the UAPA. Or protesting against the CAA, that was also narrated as a form of a terrorist offense. So most of the UAPA cases, I'm going to go out on a limb over here, I don't have statistical backing for it, but most of the UAPA cases are for things like this, are either blatantly political or people in the wrong place, wrong time, just picked up by the police as a convenient scapegoat. So there needs to be some narrative built up nationwide around India, built up about what the effects of the UAP are on the ordinary lives of people.
Thank you, Mayur. I really hope that narrative does get built and eventually we're in a position, either through a judicial route or perhaps even better, a legislative route, to end some of these just extreme legal excesses, right? And at least get to a place where maybe the judiciary and the judicial capacity still remains a challenge that we need to solve, but at least the in-law procedures that deny us civil liberties are struck off one after the other. Mayur, thank you so much for joining me on BIC Talks. I really learned a lot, and I'm sure that our listeners have as well. Thank you.
Thanks for having me.
Thank you for listening in till the end. Please share this episode with a friend on social media, WhatsApp, or anywhere else. It would mean the world to us. And in case you're listening via iTunes or Apple Podcasts, please leave us a rating and a review. Subscribe to BIC Talks on email or your favorite podcast app, and don't miss out on future episodes. This episode of BIC Talks has Gaurav Krishna as our sound engineer, with support from S. Sarvanaraj and Lekha Naidu. And the accompanying episode artwork was made by Chandni Venkataraman.
Thank you for listening to this episode of BIC Talks. This podcast can be accessed on our website bangaloreinternationalcenter.org, as well as on any of your favorite podcast platforms. Tune in for new episodes every week, and do subscribe to our YouTube channel and follow our Facebook, Twitter, and Instagram pages to stay informed on our latest updates.